Hey everyone, Melissa Wick here. I own Wick Law Offices, a small business law firm here in Columbus, Ohio. And today I'm going to talk to you about more litigation drama. I represent small business owners, and my first objective is to keep them out of litigation, right? Like that's what I set my firm up to do, is to help people make sure that, the way they're running their businesses is legit and will keep them out of hot water, right? But oftentimes people come to me and they haven't used me for contract work, right? So in all the cases I'm dealing with right now are breach of contract cases where the parties, my clients had contracts that just simply weren't adequate to address the needs of the circumstances, right? So today we're going to talk about litigation, because when people get sued, they don't always understand kind of how it works, right? So you get sued, you get served with a complaint. That is when you should contact a lawyer and probably make sure you have someone to help you keep your mental health in check. So you get served with a complaint, and you pay your lawyer to then file a response to that complaint, okay? And at that point, it already feels like it's been a bit of a Herculean effort, right? But the next thing that happens is the discovery phase of litigation. And so often my clients are just like beside themselves when this part of litigation happens, So what it is you'll receive in the mail the first thing you'll receive is something called a request for production of documents, right? And so that's pretty self-explanatory. It just is it's a set of questions to you, asking you to produce documents in your possession, documents, cell phone records, text messages, sometimes, certainly the contracts, emails are certainly fair game. Any documents they want, so tax returns, minutes for your business, anything that the plaintiff or defendant is requesting that they find materially relevant to the case, right? So that's the first thing. You'll get served with this request that's asking you to go digging for a bunch of documents that you probably don't have at your fingertips. And so what I find is my clients get like super upset, and they get super bent out of shape about it. Like they just feel like it's a huge invasion, and it does feel that way. And so what I will say to them is, look, we have to figure out how to manage your thinking around this, because at the end of the day, the court is going to say, produce these items, right? Like I can help narrow the scope of that. That's my job as a lawyer, to help sort of decide what I think is relevant and maybe make objections if certain stuff they're asking for doesn't really seem relevant. It's not likely to shed light on any particular fact in the case, then I can object to it. But most of the time, relevance is a really low bar, right? So most of the time, you're going to be producing an enormous amount of documents, and part of your job is to not be super resentful about that. And the second thing you'll get served with is something called interrogatories. So they come in sets, right? You get the first set of interrogatories, and generally the opposing party is allowed to ask in those interrogatories 40 questions of you. Like, they can ask just general questions that they want to know the answers to that are relevant to the lawsuit. So, and when people get those, again, they're just sort of like, what, that seems so nosy. How do I even answer this? So that's part of litigation as well. You will get served with interrogatories, which are just questions asking you to kind of like write an explanation or answer in writing the question that they're asking, right? So again, your lawyer can object to certain interrogatories, but not nearly as many as you think, right? You might think, no, I'm going to get a lawyer and I'm not going to respond to these. My lawyer's going to object. And that is just simply not accurate, right? Because most of the time, the questions in the interrogatories are generally in the ballpark of relevance, right? So you generally do have to provide written responses to. The next thing you might get served with is something called a request for admissions. And a lot of my clients get super bummed up about this as well, because it's like, you can only answer admit or deny. Like, you can't say I admit but, or I admit but this is a reason this is true and this is my excuse for admitting. Like, it's just admit or deny, and that's it. Yeah, so there's no like yes but option. So that's another tool in discovery that lawyers use to kind of generally isolate the facts, right? So a lot of times requests for admissions are really pretty basic to the case, and they're just like not something that is highly controversial. So a request for admissions is just a way, most attorneys use it as a way to just kind of like limit obvious issues that they don't want to spend time on in trial. And then the last piece of discovery that you may receive is a notice of deposition, right? So a deposition is a really fun party where everyone gets together, opposing counsel, your attorney, you and the opposing party, and you sit in a little room, conference room with a court reporter, and you basically get to fire off questions at each other. And the best part, the best part is that there's no judge there to sustain or deny objections. So like objections are just kind of for the record. So you have to answer, in most cases, all the questions that the opposing counsel is asking of you. And a lawyer's job is to object for the record so that those can't be admitted later in court. However, it's still like a relatively stressful process for most parties, and most parties feel kind of like violated by it. But I'm here to tell you that it's really typical, right? Like it's really typical. It's a way that lawyers sit down and can ask the questions that they think their case is kind of hinging on, so that they can get some insight into whether or not they should settle the case, whether or not the case has any chance of settling, whether they have a very strong case, or if there's facts that they didn't know about. So depositions are a necessary part of litigation, although they're not fun. So all of this discovery there's a purpose behind it. So the reason that lawyers do all this thorough discovery is because, like, as litigation progresses, there's a point in litigation where people file motions. Each side will file a motion asking the court to kind of give them relief on the counts that they have pending in front of the court. So all this discovery is a way that you can collect evidence so that you can like convince the court that you've already made your case, right? And this doesn't happen very often, but it's a really crucial part of litigation, right? Writing that motion is called a motion for summary judgment. And every lawyer in litigation knows that, those are long shot motions, but they're also a really great way of getting your case kind of prepared, figuring out what angles you're going to take on each kind of point of contention, and then imprinting the facts, your version of the facts on the court, right? It's a relatively important motion. So I understand, like, because I know from experience, I've done litigation for years and years and years, and my clients are usually going through so much emotionally when they're in litigation. Like, oftentimes there's a lot of self-blame, or oftentimes they're really in victim mode, right? And like neither one of those are very productive to like showing up the way that I think most people would want to show up. Like being victimized by a circumstance by saying like this shouldn't be happening, or why is this happening to me, doesn't really help you. Even if like your brain can find evidence of the truth of that, like it doesn't serve you, because the fact is that it actually is happening. So usually I tell people, hey, like just accept the lawsuit as meant to happen because it's happening, and don't do that dance in your brain which just chews up time and energy that it shouldn't be happening, because it is happening and it is a reality. And then the last thing I'll say is just like really get a grip and understand that the way you're thinking about the lawsuit, the way you're thinking about it is going to affect the way you feel. Like understand the connection between those two things. And if you want to feel, I'm not saying you should choose to feel good. No one would choose to feel good, but if you want to choose to feel like safe, or if you want to choose to feel confident, or if you want to choose to feel compassionate for yourself, those are feelings that you can choose, and then you can think thoughts that fall in line with those feelings. And that's another way that I try to help my clients deal with litigation in a way that's more productive and more helpful to them as a whole. So again, my name is Melissa Wick, and I own Wick Law Offices. It's a law firm for small business owners. Thanks for watching.